Welcome everyone to the Changes to Orange Book Patent Information session. We have a lot of great information ahead. Commander Kun Chen discussed the foundational aspects of Orange Book patent listing information and briefly touched upon about how changes are or can be made to the patent information listed in the Orange Book. This presentation will provide a deeper dive to specifically cover changes to Orange Book patent information. This presentation will be the first of two advanced topics and patents that I'll cover at SBIA this year, the second being the patent listing dispute process in session 5. And to introduce myself, my name is Alicia Chen. I'm the team lead of the Orange Book staff in the Division of Legal and Regulatory Support and the Office of Generic Drug Policy. The goal of these presentations, these advanced patent topic presentations, will be to give you a fuller understanding of the ins and outs of these patent processes as they relate to the Orange Book. I'll tell you a little bit more about what we'll cover in today's presentation. This session will discuss how to submit and make changes to patent information. That'll include an in-depth discussion about patent expiration date extensions, as well as a discussion of the patent delisting process. Sometimes you'll hear them discussed as patent withdrawals or removal of patents, and there's also a delisted patent list that I'll talk about that's accessible from the Orange Book website. And then last is what patent information should be submitted specifically in connection with supplemental approvals, including quote-unquote RX-to-OTC switches. That's a nickname for prescription to over-the-counter switches. And by the end of this session, I'll expect you all to be well-versed in these topics on this slide so that you'll be able to submit the correct patent information change each time. In terms of the regulatory framework, the final rule that implemented Title 11 of the Medicare Prescription Drug Improvement and Modernization Act of 2003, fondly known as MMA, amended provisions of the Federal Food, Drug, and Cosmetic Act, the FD&C Act. So you'll see that there's a Federal Register notice, the 81 FR 69580, that was published in 2016 that provided a foundational basis for many of these changes. In addition, there are other updates and modernizations to processes that have been made since then that we will definitely also cover in this presentation. Now, I want to cover something that I would consider a foundational piece of information that many of you probably already know. Is there a specific format in which patent information needs to be submitted to the agency? For those of you who heard Commander Shen's presentation or who are merely reading the title of this slide, you'll know that the answer is a resounding yes. The forms FDA 3542A and 3542 are that format. In this slide, I'll spend a little bit of time talking about the difference between the two, but wanted to point out that the requirements for the submission of patent information generally can be found in 21 CFR 31453. And it's outlined there that the agency won't accept patent information unless it's submitted on the appropriate form, which are the ones that are in this title, the Form 3542 or 3542A, and contains the information required. In addition, one of Commander Shen's key points was to highlight the difference between the two forms. Since the two forms do get confused fairly regularly, this is information worth repeating. I'll give a brief recap. When the NDA holder submits patent information with an original NDA amendment or supplement prior to approval, a 3542A is relevant. If the NDA holder is submitting patent information prior to approval, like it says on the bullet point above, this is the form to use. In contrast, upon and after a relevant approval, the question for an applicant holder is then whether they should submit a Form FDA 3542 in order to list the patents in the Orange Book. Commander Shen had mentioned the types of patents that are relevant for listing, so I won't go into that again. Suffice it to say that if the NDA holder is submitting information on a patent that claims an approved drug or an approved method of using the drug after approval of the NDA or supplement, then you would use the Form FDA 3542. Again, the agency will not list or publish patent information in the Orange Book if it is not provided on this form specifically. And the last segment of this presentation will also focus in on the supplements piece of the puzzle. And so in terms of the patent information submission, I mentioned it in the prior slide. And to repeat, the Orange Book lists patents per Form 3542, not the 3542A. The patent forms are required to be submitted electronically as the Electronic Common Technical Document, or ECTD. This requirement has been in place since May 5th, 2017, in which NDAs, new drug applications, ANDAs, which are abbreviated new drug applications, and BLAs, biologics license applications, must be submitted using ECTD format. Submissions that don't use ECTD format will not be filed or received. And then just for reference, the ECTD is the standard format for submitting applications for amendments and also supplements, and is part of FDA's Center for Drug Evaluation and Research, under which ODD is housed, and is also for the Center for Biologics Evaluation and Research, CDER. And as a quick reminder, per ECTD guidance, NDA submissions must be accompanied by an FDA fillable form, such as a Form 356H in most cases for patents. Outside of the patent information submitted to the original NDA, every other submission of patent information must bear prominent identification as to its contents. That is, it must be labeled as patent information, or if it's submitted after the approval of an NDA, it should be labeled time-sensitive patent information. In the last session, you saw a walkthrough of the overall Form FDA 3542. Right now, we'll go through a hypothetical patent listing change. I'll reiterate that a new Form FDA 3542 must be completed when the Orange Book listing information needs to be updated. In addition, make sure to use the most recent form. I'll make a note that these forms expire every few years, so if you want to guarantee that you're using the correct version of the form, then accessing the forms from the FDA Forms website linked in Commander Shen's presentation will ensure that this happens every time. Our most recent forms are posted there. And then in particular here, I'll highlight a few of the sections of the form that should be carefully reviewed when submitting a change to the patent listing. So in the hypothetical situation, let's say that a drug product has patent 1234568 that's already listed, which we'll call for short the 678 patent. 678 patent already has a method of use patent. It's a method of use patent with a use code U19, treatment of inflammation. If an additional method of use needs to be added as a result of a supplemental approval, the NDA holder also must submit patent information for any supplement if the description of the patented method of use in the Orange Book would change upon approval of the supplement. So going into the form, Section 1G talks about and it asks about whether the patent was previously submitted for listing. In this case of the 678 patent, since the method of use they're submitting is new, and in addition to the U19 already posted, then there was already a prior Form FDA 3542 patent submission, and Section 1G's answer would be yes. Next, Section 1H provides a text box to explain all of the relevant changes to the prior patent form. Of particular interest to the Orange Book is changes to the form that impact the listing of the patent in the Orange Book. In the 678 patent case given, the NDA holder would need to specify that there is a new method of use to add to the patent listing. And then if this applied, then any other relevant changes would also be included here. Other relevant changes may be entered into Section 1H and may include items such as change to expiration date for patent term restorations. I'll discuss patent term restorations in a few slides. And don't worry, you'll definitely have more space in the real Section 1H of the 3542 form. This snapshot is condensed just for the sake of the demonstration of this slide, but you'll have plenty of space to add the text relevant to the changes to the patent listing. In terms of submitting changes on Form FDA 3542, there are a few additional sections that I wanted to point out here that are often not completed correctly and would result in a notification of incomplete patent form to the submitting NDA holder. That brings me to the point that it's important to verify the accuracy and completeness of the form. One of the most commonly mistaken sections is that Section 1E, U.S. agent may not be populated or is populated incorrectly. If the NDA holder has any foreign patent owner or NDA holder specified in the form, then 1E is necessary. And be careful to select the correct checkbox corresponding to the applicable response, whether it's the U.S. agent for the patent owner, the NDA holder, or both. If there's a different U.S. agent for a foreign patent owner and for a foreign NDA holder, then two Section 1Es should be populated in the form with the corresponding checkboxes for each one selected. Commander Chen also mentioned the changes made to Section 4, specifically that it's important to name the relevant section and subsection of the labeling for method of use patents. And then lastly, please make sure that the form is signed in Section 6 as well as dated. Now we can talk a bit about the regulatory requirements for patent information change submissions. 314.53 talks generally about submission of patent information, and then 314.53F talks about correction to patent information errors. The presentation that I'll provide in Session 5 on patent disputes will go in depth into 314.53F1, which is correction of patent information errors requested by persons other than the NDA holder. For this section, however, 314.53F2 is requested by the NDA holder. In other words, the NDA holder can initiate their own changes to patent listings, and this regulation talks about some of the triggers for these changes. The revisions from MMA had different changes or corrections of patent information that were required that would facilitate the efficient enforcement of the FD&C Act. First, patent or patent claims that no longer meet the statutory requirements for listing should be submitted as a change to patent information. The NDA holder has requirements to promptly notify. And then second is a patent term restoration, or also known as expiration date extensions. And then lastly is submission of corrections or changes to patent information. These must be submitted as appropriate in an amendment or supplement to the NDA. Now, going back to that first one, the statutory requirements no longer met, is talked about in the Orange Book question and answer guidance about how an NDA holder should approach these patent listings, as well as 314.53 F2I. The MMA expanded the scope of documentation that an applicant must submit to the agency regarding the patent-related court actions and written consent to approval to ensure that the FDA is promptly advised of information that might affect the timing of approval of B2s or ANDAs. So if the NDA holder is made aware that a patent or patent claim no longer meets the statutory requirements for listing, such as if a court finds a listed patent is invalid or unenforceable from which no appeal has been or can be taken, then the NDA holder must promptly notify FDA to amend or withdraw the patent information and request that the patent information be removed from the Orange Book. If the NDA holder is required by court order to amend patent information or withdraw a patent from the Orange Book, the NDA holder must submit an amendment to its NDA that includes a copy of the court order within 14 days of the date of the order entry. And so in this situation, you can put these two bullet points together to know that a prompt notification in terms of a required court order is within 14 days of order entry. This should bear the identification, the submission should bear the identification of time-sensitive patent information. Next, if the term of a listed patent is extended for a patent term restoration, the NDA holders must submit corrections to patent expiration dates to allow for prospective 505(b)(2) and ANDA applicants to have timely notice of changes to the asserted patent coverage for a listed drug. The NDA holder is required to submit corrections to the expiration date of the listed patent on Form FDA 3542. In terms of tips for Sections 1G and 1H, Section 1G should say yes if it's an already listed patent, and then Section 8 really should note all of the reasons for the different changes to that patent form. In this case, if it's a patent term restoration and expiration date extension, then that would be specified in Section 1H. And last, the expiration date correction must be submitted within 30 days of receipt of relevant documentation, which may include either a certificate of extension as described in 35 U.S.C. 156E1, or documentation of an extension of the term of the patent, and which is often a temporary extension provided by the USPTO for a patent with a pending application for extension issuance or denial. Now let's move on to patent corrections or changes, and this is outlined in 314.53F23. Corrections or changes to previously submitted patent information other than withdrawal of a patent and request to remove a patent from the list must be submitted on Form FDA 3542 or 3542A as appropriate, and an amendment or supplement to the NDA. FDA will not accept the corrections or changes, like I mentioned, unless they're submitted on the appropriate forms. Each of these patent submissions, except for information submitted with the original NDA, must bear prominent identification, which I've mentioned previously. And so typically, the identification will be patent information, and then if it is submitted after approval of an NDA, then it'll be called time-sensitive patent information. Exceptions to the submissions of forms, the form requirement, is that a request for withdrawal of a patent and a request to remove a patent from a list, which is also known as a patent delisting, does not need to be submitted on a 3542. So I'll talk about that in later slides, but let's talk about a hypothetical situation here. Let's say that an NDA holder has submitted a new Form FDA 3542 with a patent expiration date extension for an already listed patent, U.S. patent number 23456-789, or the 789 patent for short. Now, this is required to be submitted on the Form FDA 3542 after approval with the relevant expiration date field updated on page 1 of the form. Section 1G should say yes, since the 789 patent is an already listed patent with an expiration date in this hypothetical situation. And then Section 1H would note that the reason is for patent term restoration or extension of patent expiration date. The category of untimely filed patent information was expanded with MMA to include certain amendments to the NDA holder's description of the approved method or methods of use claimed by the patent. And in terms of the definition of how a patent is considered timely, if the changes must be submitted within 30 days of the following: within 30 days of patent issuance, within 30 days of approval of a corresponding change to product labeling, within 30 days of a decision by the USPTO or federal court that is specific to the patent and alters the construction of a method of use claim or claims of the patent. And these revisions were intended to reduce delays in approval related to overbroad or ambiguous use codes. In addition, the circumstances as mentioned in the patent listing dispute regulation, which I'll cover in my next presentation, allow for timely amendment to the description of the approved method or methods of use claimed by the patent. Outside of these circumstances, an amendment to the description of the approved method of use claimed by the patent will not be considered timely filed. I must also add that there is also the last circumstance in which if a method of use patent was submitted, but that the form itself was incomplete or showed that the patent wasn't eligible for listing, then the NDA holder would get a notification from the FDA regarding the need to submit an acceptable Form FDA 3542 within 15 days of the agency's notification in order to be considered timely filed. We'll also go into that 15-day notification in the patent listing dispute presentation. So of the things in this slide, we'll talk about the first 3 in this presentation and then the last 2 in the next presentation. Now, how can an NDA holder request a patent error correction, such as a request for a patent submission date correction? NDA holders should email these error correction requests, including a justification for the request, to the Orange Book staff at our mailbox, orangebook@fda.hhs.gov. And I'll emphasize here that this is information regarding the error corrections by the NDA holder for their own patent listing for the sake of their corrections. And the U.S. agent should contact the agency with this correspondence. Requests will be considered on a case-by-case basis and reviewed for accuracy, and this includes a review of all of the Form FDA 3542 submissions in comparison to the information provided by the email, and if accurate that there was an error made, then the information is updated in the Orange Book as soon as it is practicable. This information and more is included on the Orange Book Frequently Asked Questions on the Patent and Exclusivities, the Orange Book FAQ on Patents and Exclusivity page. Now, an important point that's worth mentioning in this slide is that there is a consequence of untimely filed patents. And so what actions, I'll frame the question this way: what actions must a pending ANDA or 505(b)(2) applicant take if patent information is untimely filed? And the answer is, generally, if patent information is untimely filed, and a previously submitted ANDA or B2 applicant is not required to submit a patent certification or statement to address the patent or patent information that is late listed with respect to the pending ANDA or B2. Now let's come to the first challenge question. The following are the reason or reasons that an NDA holder may request changes to Orange Book patent listings. A, patent expiration date changes. B, patent claims no longer meet statutory requirements. C, corrections to previously submitted patent information. D, all of the above. Or E, none of the above. I'll give you a few seconds to think about that. And the answer is D, all of the above. So all of these, expiration date change, no longer meeting statutory requirements, corrections to previously submitted information, along with a couple of other situations, are reasons that the NDA holder may request timely changes to Orange Book patent listings. Other changes that weren't mentioned on this slide are supplemental approvals that require changes to previously submitted patent information that are covered in the next section of this talk. The last section of this talk, or changes in response to patent listing disputes, which I'll cover in the next session, number 5. Now let's switch gears and launch into the second part of this presentation, Orange Book patent delisting. How does FDA receive and process a request from an NDA holder for removal of a patent from the Orange Book? In this section, we'll cover the answer to that. We'll cover the NDA holder patent delisting submissions, as well as the Orange Book delisting process to answer that question. In terms of the patent delisting submissions, 314.53 F24 is describing the submission of patent withdrawals and requests to remove a patent from the list. These delisting submissions may be submitted by letter, and an NDA holder may submit a withdrawal of a patent and request for removal of the patent from the Orange Book by letter to the NDA file. In addition, as mentioned in this first bullet point, it is not required to be submitted on Form FDA 3542. The Form FDA 3542 is fine to submit as a withdrawal request with the relevant fields sections 1G and 1H populated appropriately, but it's not required. The NDA holder can instead submit a letter, and in either case, the NDA holder should clearly and prominently identify that it is seeking patent withdrawal and removal from the Orange Book under 21 CFR 314.53 F24. And therefore, the submission should be identified as time-sensitive patent information. And then the withdrawal of letter or 3542 submission must contain the following information: the NDA number to which the request applies, each product or products approved in the NDA to which the request applies, and then, of course, the relevant patent number. If all of this information is not included, it's not considered a complete patent delisting submission and may not be able to be processed by the Orange Book. In terms of the process for the patent delisting, first of all, the FDA will screen the patent delisting information to ensure that the required information is included. So, has all the required information been submitted as specified in the prior slide? If so, then an assessment based on 180-day exclusivity eligibility determines whether the patent can be fully removed from the Orange Book. If there's no first applicant eligible, or upon the expiration, extinguishment, or relinquishment of 180-day exclusivity, then the FDA will remove a patent or patent information from the Orange Book when the NDA holder has informed us that the patent no longer meets the statutory requirements for listing. And for patents that are fully removed, they will appear in the delisted patents list, which I'll show you shortly. For patent information that is to be removed from the Orange Book, that actually must come on a Form FDA 3542. And in the case that it's eligible for removal, that will appear as a removal from the Orange Book, but will not appear in the delisted patents list because it is merely patent information that is being removed, such as a method of use removal. However, if there is a first applicant that's eligible for 180-day exclusivity based on a paragraph 4 certification to the patent, then the patent must remain listed. And the marker in the Orange Book is the delist flag yes, in which the patent remains listed. I'll show a couple of snapshots of how that'll look in the Orange Book. I'll show a couple of snapshots in this slide to show you how the Orange Book patent listings would look before and after a patent delisting request has been processed. First, if a delist has been found to be impermissible because a first applicant may retain eligibility for 180-day exclusivity based on the P4 certification to the patent for a certain period, then the patent delist request flag yes or Y will be displayed. This indicates that the NDA holder has requested that the patent be listed, but that the patent has remained listed because of what I mentioned previously and is not able to be fully removed. Next, if the patent was not a placeholder for 180-day exclusivity and is permissible for delisting, then the patent is removed from the drug product listing in the Orange Book and placed in the delisted patents list. As a note on submission date, as mentioned in the final rule, the submission date of patent information provided by an NDA holder after approval will be the earlier of the date on which the Form FDA 3542 is date stamped by the Central Document Room or officially received by FDA in an electronic format. This slide reiterates and focuses in on the delist requested flag and summarizes what I've mentioned in the prior slides regarding why the patent may be retained in the listing and the drug product list due to a first applicant retaining eligibility for 180-day exclusivity. An NDA holder has requested that a patent be removed from the Orange Book in this hypothetical situation. The patent remains in the Orange Book with a delist request flag. When will the patent be removed? We'll get this question now and then. As we mentioned previously, a patent may remain listed for a certain period of time even if the NDA holder requests that it be removed. ANDA applicants must submit or maintain appropriate certifications to the patent, notwithstanding the NDA holder's request to remove the patent. Applicants submitting a Section a 505(b)(2) application are not required to certify to a patent when the delist request flag is set to yes in the Orange Book. And lastly, the patent is removed from the Orange Book after any associated 180-day exclusivity has expired or has been extinguished or relinquished. The Orange Book Delisted Patents List is a list of patents that have been delisted since the most recent annual edition of the Orange Book. You can follow the hyperlink to see the entire list. The following slide provides a snapshot of the current delisted patents queue. As you can see, it shows 1 to 50 of 165 entries. There are currently over 150 entries. This can be sorted or exported similar to other data sets contained in the Orange Book website. The information captured in this view includes patent number, patent use code, and then various pieces of information regarding the application, including its active ingredient, dosage form, etc. Now let's see what you remember from this patent delisting section. This is challenge question number 2. Patent delist or withdrawal requests may be submitted to the agency on the following. A. Form FDA 3542. B. By letter. C. On Form FDA 3542 or by letter. Or D. None of the above. And I'll give you a hint that you would select the best answer to this question. The answer is C, on Form FDA 3542 or by letter. There is no requirement to submit patent withdrawal requests on Form FDA 3542, so it may be most expeditious for an NDA holder to submit just that cover letter as the patent withdrawal letter. Just make sure to prominently identify the submission as time-sensitive patent information. I'll also note here that we've talked a lot about full patent delists or full patent withdrawals and haven't touched too much upon patent information removal. So typically patent information removal talks about methods of use that are being removed from the patent listing. For example, if that patent 789 was both a drug product patent as well as a method of use patent. A delist of patent information may be a request to remove just that method of use from the patent, but to retain the patent as listed in the Orange Book as a drug product patent. In that situation, a Form FDA 3542 would be applicable to be submitted, and then the Section 1H would clearly identify that a removal of the method of use would be necessary. And then the same rules of the delist would apply in that if there was a 180-day placeholder for that method of use under that patent, then that method of use would not be able to be removed. However, since it's patent information and not a full patent delist, then it would not appear on the delisted patents queue once it was able to be fully removed. And as a concluding thought is one on reissued patents. Upon patent reissuance, the original patent is surrendered and ceases to have legal effect. Therefore, the NDA holder is required to request that the original patent be removed from the Orange Book once a patent is reissued. And consistent with our regulations for any request to withdraw a patent from the Orange Book, the original patent will remain listed in the Orange Book until the FDA determines that no first applicant is eligible for 180-day exclusivity based on that P4 certification, or until after that 180-day exclusivity period has expired or has been extinguished or relinquished. Now, let's pivot over to the third and final topic for this presentation. Patent form submissions for supplemental approvals, including prescription to over-the-counter, also known as RX-to-OTC switches. Requirements depend on whether existing patent information in the Orange Book for the original NDA continues to claim the changed product and whether the published description of the patented method of use would change upon approval of the supplement. So let's unpack that a little bit more. An NDA holder must submit patent information when it seeks approval of a supplement to add or change the dosage form or route of administration, to add or change the strength, or to change the drug product from prescription to over-the-counter use, which we'll talk about in depth in a little bit. For supplements that seek approval for other changes, for example, to change the formulation, to add a new indication or other condition of use, or to make any other patented change regarding the drug substance, drug product, or any method of use, the requirements for submitting patent information depend on whether the existing patent information in the Orange Book for the original NDA continues to claim the changed product. So, in other words, if there is somebody that has, an NDA holder has a patent that's listed and they receive a supplemental approval for a new pediatric indication, but that information doesn't make any changes to the patent listing, then no new Form FDA 3542 needs to be submitted. So in terms of a situation that an NDA holder would not need to submit would be in cases if one or more of the patents were already submitted properly with the original NDA and then also claim the changed product, like I mentioned. And then next, and so in that case, the FDA continues to list the patent information. Another situation may be a patent delist, that if one or more patents were properly submitted with the original NDA, but then the changed product aren't claimed by that patent, then the applicant must submit a request to remove the listed patent information at the time of approval of the supplement. And then situations in which new patent forms must be submitted. If one or more patents were not previously submitted and claim the changed product, the applicant must submit the required patent information. And then the NDA holder also must submit patent information for any supplement if the description of the patented method of use in the Orange Book would change upon approval of the supplement. Patents for supplemental approvals. The Form FDA 3542 must be submitted for new patents relevant to the supplemental approval. The approval date of the supplement would be identified on the form clearly so that it would be easy to tell that the new submission was related to a timely submission related to an approval. And supplement would be selected rather than full original NDA. And in the case that the method of use is revised, then Section 4.2b would also need to be updated to align with the labeled indication as relevant. And there are Form FDA 3542 instructions that have additional information regarding writing and drafting a proper method of use for listing in the Orange Book. And the agency's role is ministerial, so the Orange Book is not going to propose or change or deny a method of use. It is the NDA holder's responsibility to submit an appropriate method of use. And so the FDA forms, you can follow that hyperlink. The Form FDA 3542 instructions is also called the Form 3542 supplement. And so just briefly talking about 4.2b, 4.2b for each method of use instructs the NDA holder to provide the description of the specific approved method of use claimed by the patent that FDA should use as a use code, and the scope of the use code must not extend beyond the scope of the patent claim. And it must only describe a patented method of use that's been approved by the FDA as reflected in approved product labeling. And so if you intend to use an existing use code that satisfies the requirements of the statute and regulations, then the submission of the use code for listing in the Orange Book should specify specifically what use code number that aligns with. And then if you're drafting a new use code, there's a limit of a maximum of 250 characters for each use code. Of note, please don't use special characters. And I mentioned the Form FDA 3542 supplement already. Now, patent submissions, I've alluded to this previously. Patent submissions have to meet various criteria as applicable and relate to different points in time in order to be considered timely filed. Patents that were issued prior to an approval must be submitted to the agency on an acceptable 3542 within 30 days after approval of the relevant NDA or supplement. And also, patents may continue to be issued throughout the life cycle of the drug product, including after approval. If a relevant patent is newly issued after approval, then the applicable Form FDA 3542 must be submitted within 30 days of patent issuance. Last, the single 15-day requirement speaks to the NDA holder's timeline for responding to FDA's notification of incomplete forms, or Forms FDA 3542 with errors, that have been submitted to the agency and therefore cannot yet be listed. As I mentioned, the requirement will be described further in Session 5. Now let's talk about RX-to-OTC switches. So an NDA could either have been submitted for a direct to over-the-counter drug product, but in the situation we're talking about here, a lot of NDA FDA-approved OTC drug products have begun their life cycle as NDA-approved prescription drugs that eventually switch to OTC status under the NDA provisions. When the NDA holder receives that RX-to-OTC supplemental approval, all of the drug product listing in the Orange Book typically remains the same, with the exceptions of the field called marketing status. In the Orange Book, marketing status is either RX-OTC or DISCN, that stands for discontinued. And so RX or OTC as designations represent the active section. And so when an RX to OTC switch occurs, then this switch will lead to a change in the status from RX to OTC. In addition, the removal of any TE codes would occur because TE codes are not applicable to OTC products. And then next here is that the RX product number is retained and just flipped for the OTC product listing. This purpose is to ensure the clarity of product listing information, as the Orange Book now retains the original RX prescription numbers and merely switches the marketing status to OTC for the same product listings. As you can imagine, there are some implications on the patent listings, which we'll cover next. For NDA holders, the following patent process information is important to be aware of if you may be going through this process at any point in the future. New forms FDA 3542 are required to be submitted for the new OTC product listings because this is considered a supplemental approval and a change to a previously listed product. Even if the patent listing itself will look the same, it is now for an OTC product, and therefore new forms must be submitted for any patent, even those that are already listed with no changes. Of course, if there are patent changes, it's fairly self-explanatory that new forms FDA 3542 should be submitted under the new applicable OTC product listing or listings with that information. Patent information that is already listed is retained for 30 days after OTC approval. This is the 30-day window in which new patent forms should be submitted to be considered timely filed. And then after the 30-day window elapses, if no new Form 3542 is received for each of the patent listings that were under the RX product, then all patents for which no new Form FDA 3542s were submitted are then delisted according to the delist process specified earlier in this presentation, because they no longer apply for the they are not applicable for the OTC listing and were listed for the RX listing. The delist flag Y, or for yes, also applies here in that those patents that are placeholders for 180-day exclusivity may also be held from full removal, while the fully delisted patents would be removed from the individual drug product listing and appear in the delisted patent section of the Orange Book website. Let's see what you know now about the RX to OTC switch supplemental patent submission process. After an RX to OTC switch supplemental approval occurs, the NDA holder should do the following. A. Submit relevant new forms FDA 3542 for OTC product listing within 30 days of approval. B. Submit relevant new forms FDA 3542A for OTC product listing within 30 days of approval. C. Both A and B. And D. None of the above. I'll give you a few seconds. The correct answer is A. In order to be timely filed, the submission of new forms FDA 3542 must be submitted for each patent that is to be continued to be listed under the OTC product listing. And this is the 30-day window for timely filing. Answer B, in contrast, is not correct because we're asking what should happen after the supplemental approval, while the forms FDA 3542 are those submitted with the supplement and prior to approval. And since B is not correct, neither is C. Last is another challenge question number 4. This is a true or false question. After an RX-to-OTC switch supplemental approval occurs, the NDA holder's listed patents will automatically be retained in the Orange Book product listings after 30 days. The answer here is false. This is a bit of a play on words. The patents are retained for 30 days after approval, but after 30 days, the listed patents are removed if no new complete Form FDA 3542s are submitted for each of those patents. All of the basic patent submission requirements apply for RX-to-OTC switch submissions, in that the forms FDA 3542 must be complete and free of errors. And if deficiencies are identified by the agency, deficiency letters are sent to the NDA holder with a 15-day window to adequately respond with a resubmission of a complete Form FDA 3542. In summary, patent information and changes are submitted and listed according to Form FDA 3542. Patent delisting requests may be submitted to the agency by letter. In contrast, patent information delisting requests should still be submitted on Form FDA 3542 with an accompanying 356H and cover letter. And last, new patent forms must be submitted for each relevant patent after an RX-to-OTC switch, and within the 30-day time frame of approval in order to be considered timely filed. After this session will be our live Q&A session for the combined topics covered by Commander Kun-Shen and I in sessions 3 and 4. So please hold your questions for that session. As a quick reminder, session 3 was an overview of FDA's patent listing process, while this topic was changes to Orange Book patent information. We'll be joined to the panel by Janice Weiner from the Office of Regulatory Policy, and we look forward to answering your questions then. In closing, timely and complete submissions of patent changes help to ensure accurate Orange Book patent listings. Thank you for your time.